En el Perú no se entiende como una empresa que es la única que no ha cumplido con su programa de inversiones ambientales esté demandando al país precisamente por trato inequitativo.
It's hard for us to understand in Peru how the only company that has not complied with its environmental commitments is accusing the government of unfair treatment.
Más aún cuando esta empresa es la única que también ha recibido 2 veces el beneficio de ampliaciones en su programa de inversiones ambientales.
It's the only company that's received the 2 extensions.
Pero al mismo tiempo, como mencionaba, en el Perú, Doberran también está diciendo que en el Perú hay una amenaza de expropiación indirecta.
The company is also saying there's a threat of indirect expropriation of this operation.
Y la amenaza de expropiación indirecta, la supuesta amenaza de expropiación indirecta, es porque el Perú le está reclamando a Doberran que pague los impuestos que no ha pagado.
And what they're claiming is the basis for the risk of indirect expropriation is that the government is calling on the company to pay the taxes that it has not paid.
En el Perú se ha conformado una junta de acreedores de Doberran porque es una empresa que le debe no solamente al Estado peruano, sino incluso a varias empresas mineras. Y en esa junta de acreedores, por supuesto, el Estado peruano está presente.
So a creditors group has been formed to deal with a company that's not only the Peruvian government but other mining companies that Doberran owns money to. The Peruvian government is part of this group of creditors.
La empresa está utilizando como mecanismo de presión el arbitraje internacional y lo está utilizando precisamente para obtener nuevamente una tercera ampliación del plazo de sus inversiones ambientales.
So in this context, the company is clearly using this international arbitration, this trade case, as a way to pressure the Peruvian government to give it another extension of its environmental obligations.
Como Kit ha mencionado, yo he tenido la oportunidad de estar algunos meses en el gobierno y he visto cómo la empresa viene desplegando todas sus estrategias para precisamente presionar y chantajear con este proceso de arbitraje al amparo del TLC con los Estados Unidos.
So I was in the government for a few months as the Vice Minister of the Environment, and I was able to see firsthand how this company is pressuring and lobbying very hard at the Peruvian government to get this.
Por eso nos preocupó mucho en el país que un grupo de congresistas norteamericanos elaboren una carta respaldando a la empresa, respaldando a Doberran, pero además pidiendo sanciones contra el Perú, argumentando que el Perú no debería recibir financiamiento, por ejemplo, del Banco Interamericano de Desarrollo.
For this reason, we were very concerned last year when 8 members of the U.S. House of Representatives signed a letter in support of Doberran and threatening to cut off funding for Peru over this case from the Inter-American Development Bank.
Por eso para nosotros es muy importante estar acá y darles nuestra versión de lo que está pasando en el país y de cuál es el verdadero comportamiento de esta empresa de los Estados Unidos en el Perú.
For this reason, it's very important for me to be here to explain what's really going on so that you all have the other side of the story.
Gracias.
Okay. And if I can just abuse my use of the moderator's chair here, in response to that letter and also that Jose mentioned, and also to raise concerns about the situation in Peru, Congressman Grajalo's office is currently circulating a Dear Colleague letter in which it is asking, in the letter, it's being directed to Secretary of State Clinton, asking that the U.S. government not support Doberran and Renko in this arbitration. And we thank Congressman Grajalo for his support of the East and support of that. Okay, turn it over to Marco and
my guess is that the case of Chevron in Ecuador is one that needs the least introduction. Generally, as people have heard a lot about it over the last few years, but I will give a brief overview because some of the history of the case is relevant to where we are now in the arbitration. I should say that I'm not representing the plaintiffs in the litigation. I don't have any formal affiliation with them. My organization has acted as an amicus, has filed friend of the court briefs at several stages in these proceedings. So as I'm sure you know, this case arises out of Texaco's operations in the Ecuador and Amazon, which have allegedly led to widespread contamination in the Oriente region of Ecuador, and also allegedly resulting in widespread health impacts, additional cancers and other diseases, and a number of deaths that have been attributed to this contamination. Texaco's investment in Ecuador ended in 1992 when the oil consortium that it operated broke up. And for 20 years prior to this, Texaco had operated, was the sole operator of the consortium extracting oil. In 1992, they handed this over to Petroecuador, the state oil company. And Texaco left the country, essentially. In 1993, a group of plaintiffs filed suit against Texaco in the United States, arguing that their operations had caused extensive environmental contamination. Also in 1993, the U.S. and Ecuador agreed to a bilateral investment treaty with an investor-state arbitration provision along the lines of the others that have been discussed here today. If you're following the dates, you might have noticed that Texaco pulled out of the country before the bid was signed, so more on that later. Possibly in response to the lawsuit in the United States in 1995, Texaco negotiated an agreement with the Ecuadorian government that essentially parceled out the environmental liability in the case, an agreement which none of the plaintiffs or affected communities were party to, but they basically said, okay, Texaco is responsible for this part, Petroecuador is responsible for this part, and Texaco is going to go do its remediation for its part. And in 1998, they concluded another agreement with the Ecuadorian government saying that all of Chevron or Texaco's obligations under this agreement had been fulfilled. They've done the remediation of their part, and all their obligations are complete. Now, meanwhile, litigation was ongoing in the United States. And Texaco's main argument in that litigation was that the case should be heard in Ecuador, not in the United States. Finally, in 2001, shortly after Chevron had merged with Texaco, Texaco and Chevron got their wish. The Second Circuit Court of Appeals granted their request that the case be dismissed out of U.S. courts in favor of an Ecuadorian court on the condition that Texaco submit to the jurisdiction of the Ecuadorian courts. Litigation was subsequently filed in Ecuador, and it has been ongoing ever since. The case in Ecuador did not turn out how Chevron anticipated. There's a lot of allegations flying back and forth about misconduct on both sides, which I'm not going to get into because, from my perspective, for the issues at play when we get to the arbitration here, it doesn't really matter. Even if you accept that everything Chevron is saying is true, that Chevron's people have not been engaged in any misconduct, and that the Lago Agrio plaintiffs, as they are known, have been, and their lawyers have been engaged in widespread fraud, it shouldn't change the analysis about how dangerous this arbitration proceeding is. So when Chevron was feeling that the case was not going its way, in 2009 it filed an arbitration request, a notice of arbitration against Ecuador, basically arguing that even though the government of Ecuador wasn't a party to the litigation in Ecuador, that its rights as an investor had been violated because the Ecuadorian courts were treating it unfairly. and that the Ecuadorian government was colluding with the Lago Agrio plaintiffs to try to put pressure on the courts to secure a judgment against Chevron. This raises a number of troubling issues. Number one, the Lago Agrio plaintiffs, the people who were allegedly affected by all this contamination, are not party to this arbitration. That wouldn't necessarily be a problem if the only thing Chevron was asking for was money from the Ecuadorian government. Chevron could have come in and said, well, we've been harmed, the Ecuadorian government needs to pay us, it doesn't matter what happens in the court case, you know, that's the business of the Ecuadorian courts, but if we've been wronged, we deserve compensation. But that's not what Chevron did. What they did is they asked for a termination of all the court proceedings against them in Ecuador, and a statement from the arbitral panel that any judgment against them in the Ecuadorian court is unenforceable. And so far, the arbitration panel has gone along with some of Chevron's requests to try to shut down this litigation. Along the way, they've issued a couple of interim orders and awards that asked the Ecuadorian government to essentially stop this case, to take all measures necessary. The most recent award was issued in February of this year. And the arbitral panel issued an award against, essentially, an award is the arbitral equivalent of a judgment, essentially, against the government of Ecuador, requiring it to take all measures necessary to suspend or cause to be suspended the enforcement and recognition within and without Ecuador of the judgments in the Ecuadorian legal proceedings known as the Lago Agrio case, and specifically to take such measures to preclude certification by the government of Ecuador that would cause these judgments to be enforceable against Chevron. So what the arbitral panel did was to order the Ecuadorian government to interfere in its own court system. In an arbitral proceeding in which